Okay, so good afternoon, everybody. Let's start this final plenary session of the 2026 Migration Conference of the Academy of Law and Migration and the ADIM-IntoME Jean Monnet Center of Excellence. I have the pleasure and the honor to moderate this session, which is going to be extremely insightful and interesting because we will deal with a key aspect of the new Pact on Migration and Asylum, which is the procedural crisis. The plenary session can be framed as a session of the hidden infrastructure of asylum law, of protection, the place where the EU asylum system decides whether rights are effective, delayed, diluted, or made practically unreachable are the procedures. The title, The Procedural Crisis, works well because it's both descriptive and prescriptive. It points to the dysfunctionalities of asylum procedures, but also questions how crisis has become a sort of governing technique in EU asylum law. Thus, we will depart from a simple but uncomfortable truth, which is that in asylum law, procedures are not merely a path toward protection. Procedure often determines whether protection is real at all. Time limits, admissibility filters, border procedures, safe country presumptions, access to legal assistance, judicial review shape not only how claims are processed, but also who can effectively make a claim, how it is heard, and whether an error can be corrected in time. So the title, The Procedural Crisis, it is deliberately ambiguous, but it's a sort of constructive ambiguity because we wanted to refer to this duality, to this twofold understanding. We want to point out at the delays, the backlogs, the fragmented practices, overstretched administration and courts, but also invite all of us to ask whether crisis has become a sort of legal and political grammar through which procedural guarantees are repeatedly compressed in the name of speed, efficiency, and deterrence. Thus this title captures a sort of central paradox in contemporary EU asylum law, not only Europe, worldwide. On the one hand, procedures are often presented as a problem. Procedures are too slow, too fragmented, too vulnerable to misuse, to abuses, too burdensome for administration and courts. On the other hand, procedures is also the main guarantees through which the right to asylum, non-refoulement, and effective judicial protection become operational. When it comes to the new Pact on Migration and Asylum, what is the promise? The promise is a more predictable, coordinated, and efficient system. What are the consequential choices of this premise? Screening, border procedures, accelerated procedures, admissibility rules, safer country concept, tighter deadlines, and new forms of responsibility sharing, responsibility allocation. So the question for our plenary session is not only whether the Pact solves the procedural crisis, but also whether it institutionalizes a sort of Christ-driven model of procedures. And I'm going now to the nitty-gritty because I don't want to rob too much of the time. So what happens when acceleration becomes the dominant paradigm of asylum procedures? Can we still individualize the asylum seekers in compressed time frames and controlled spaces? Are border procedures legally coherent and practicably feasible, especially when it comes to the responsibility of frontline member states, or they need to produce further bottlenecks, containment, and litigation? So exactly what it was purposed to remove or limit. Thus, this title embodies not only a paradox, but also a provocation. Perhaps we should not only ask how law responds to crisis, but also how asylum law itself has been crucified. So how exceptionalism, urgency, and emergency reasoning become normalized within the ordinary legal framework. And this question, exactly whether the pact moves us beyond the crisis or whether it codifies the crisis as a permanent procedural condition. All in all, the procedural crisis is not only a crisis of slowness, it may also be a crisis of excessive speed, of procedural compression, and of legal presumption that move complexity away from the individual file into abstract categories. I would like to invite each of speakers. We have the opportunity to discuss those topics with the leading scholars in migration and asylum in Europe, and I would like to invite our distinguished speakers to address both dimensions. First of all, the concrete procedural rules and the broader legal imaginary they reflect. Second of all, responding to these questions, are we seeing a more efficient asylum system, a more restrictive one, or a new one, a sort of shifting paradigm, a transformation of asylum itself? And I have the pleasure to give the floor to our first speaker, who will address this very broad topic from the perspective of acceleration and due process. So I'm inviting to take the floor to Professor Jürgen Bass, University of Gießen, with a presentation entitled Due Process under Inclusive Legislation and the Court of Justice in EU Asylum Procedures. Jürgen, you have the floor. Thank you.
Oh yeah, that's much better than and unsurprisingly so it works better than. Can you hear me back there? Is the sound okay? So give me a sign once it doesn't work anymore. Thank you so much. Thank you for the thoughtful and difficult introduction, Daniela. So it's I'm afraid you're asking for much more very important things than I can offer. So I try to make the best out of it. So what I'm going to do? So my topic is a rather general one. Therefore, it obviously makes sense that I'm the first speaker in this session. I try to share some general reflections, some thoughts on the historic moment in which we are in, on the current state of the EU's asylum system, on the eve of the Pact's implementation. So the extended phase of legislation is over, at least at the level of the European Union. Now implementation is the hour of the day. It may also involve legislation, but for the years to come, at the actual application of these new rules. And I'm quite convinced that we will learn a lot from experiences that phase. So it's kind of difficult to predict what the issues will be, and I will share some thoughts on that. And my main argument will center on the Court of Justice, on its role in the coming years. And my point is, specifically referring to the issue of procedures, of asylum procedures, that the court will have to activate constitutional guarantees of due process in order to remedy the legislation that had been adopted by the EU legislator, which will prove to be, to some degree, be insufficient. And I will introduce a concept that tries to make sense of the type of insufficiency. I will introduce the concept of under-inclusive legislation, and maybe it will prove to be helpful to analyze the forthcoming conflicts and legal debate. Just to briefly mention the context from which this talk emerges. So there's a larger research project of which I'm a part. It's called the ADIM-IntoME project, Human Rights Discourse in Migration Society. It essentially deals with the intersection of migration and human rights. It's an interdisciplinary project that discusses the notion of human rightization in law, politics, and everyday practice. And from one of the legal projects of this larger collaborative work, parts of these thoughts are drawn from that project. And if you're interested, then you see the website here. Okay, let's start. What will be the structure of my talk? Essentially, I will make it in 3 steps. First, I ask myself and share some answers in what's actually new in the new pact, these new asylum systems. The better we understand what has essentially remained the same as before, the better we understand the new challenges. So therefore, I will spend some minutes on reflecting on the core assumption that the basic structure of the EU's asylum system has not changed. Secondly, I will focus on due process, and I use that term, although it's not a concept of EU law, as a shortcut for procedural guarantees enshrined in the highest level of the EU legal order, to which I refer to as constitutional law, and essentially it's about fundamental rights in that context. Okay, so I will discuss briefly what are the due process issues that are coming up from the revised EU asylum procedures. And then finally, I come to this main claim of my talk, so what the Court of Justice will have to do, namely remedying under-inclusive legislation. Okay, let's go. So what's actually new? So my main point here is there was no rupture. So of course, things have changed. My claim is not that there is not a new policy being implemented, and actually it's for the first time that revision or recasting EU legislation has led to a withdrawal of rights, to a more restrictive policy. But I would like to start with the observation that the basic structures of the asylum system has remained essentially the same. And taken from forced migration study, an asylum system is composed of the elements of eligibility, status, and access. So who is eligible to international protection, what is the status which these persons gain from the particular order, and how do they get access to that. So, and as far as the 2 first elements are concerned, it remains essentially on the trajectory it has taken since the turn of the century, since the EU legislator has taken on the role of governing this European asylum regime. The definition of who is eligible for international protection is a human rights-based approach, essentially based on a human rights reading of the Geneva Refugee Convention of what makes up persecution, and secondly, of an extended notion of who deserves protection beyond the scope of convention refugee, based on an asylum concept centered on human rights. So it's one of the most liberal systems in the global context, and still is. Secondly, what is the status which these persons who are eligible for international protection receive within the European Union? Again, with all its flaws, so the status that people receive is a very favorable one. It's essentially based on the Geneva Refugee Convention, which is not surprisingly so insofar as it pertains to refugees in the meaning of the convention, but the European legislator has extended this concept to a broader group of persons, which is not derived from international law, and with all the flaws, there are gaps in the system, for example, family unification for these persons called subsidiary protected persons, but still. The hard edge, the bad, the ugly side of the European asylum system was and still is the successful attempts of preventing many people from having access to this territorially based asylum. Still, there are hardly any legal and safe pathways to receive protection in the European Union, and there is a whole range of non-arrival policies, of deflecting people to arriving at the borders of the European Union. This is hardly a matter of legislation. It's actually so certain policies that are not enshrined in the laws and that do not depend on legislative reform, but they are in place and they're an essential element of this thing. But in all these contexts where many of those here in the room, in the political battles of the recent years have taken the stance to criticize the European asylum reform, we should reflect on the fact that there's still much to defend even after the reform. And essentially, I would like to mention that the fact there is still a right to asylum of a person arriving at the border, and once this person does so, then during the asylum procedure, he or she has a right to remain in the territory of the European Union, not somewhere else. And also these asylum border procedures, of which Philip will talk about in a minute, are taking place within the European Union, and international comparison, for example, with the US, marks the difference to this legislative decision. Where is the novelty? I would hold that the novelty essentially is the two concepts of immobilizing asylum seekers within the European Union, the general idea of doing as much as one can to combat secondary movements. So that's one of the core issues. I will not deep dive into that one because my focus is more on the second one. We have seen an increase in procedural restrictions during the various types of asylum procedures. Here, talking about procedure is talking about one of the essential novelties, or at least where eminent things have changed in the context of the European asylum system. Okay, this slide is a very general one, first for reasons of time constraints, and secondly maybe also for personal competences. I will not go into the details of the various procedures and so where are the various types of restrictions, how they are shaped. So I take the liberty of being very general in this regard, and we can discuss certain issues in more depth maybe in the Q&A. The general impression which the revised procedures give, that they are dominated by concepts of abuse, of using procedures to deter people from actually applying for asylum, and they are built on the notion that to make sure that the person who is not eligible for international protection can actually be removed. So removability is built in the concept of asylum procedure, as contradictory as that may sound. In terms of practical implementation, this is reflected, for example, in very strict and short timelines. So, and to an extent that it is not difficult to predict that there will be issues of the fundamental right to an effective remedy. So here is one of the sources of conflicts between the actual procedures as laid down in the legislation and the fundamental rights enshrined in the Charter of Fundamental Rights. Another observation in terms of procedures is the proliferation of various types of procedures. I'm hesitant to use the concept of acceleration. Of course, one of these special procedures is the accelerated procedures, but I find it hard to imagine that making a system so complex that it consists of various special procedures with all its different rules of procedure to apply, that this will actually lead to acceleration. So it's getting so complex that I would not predict that the effect of being faster will be one of the empirical results of this procedure. So the notion of acceleration seems odd to me in that context. And in addition, many of the procedures, or quite some of these procedures, are not about determining the need for international protection, but rather they are about determining the applicability of another procedure. So in the screening procedure, we're discussing as to whether the person has to go into the asylum border procedures. And in the Dublin procedure, we're discussing which state is responsible for the procedure. So the European Union spent quite some energy, in particular in terms of procedural law, not about discussing substance, but about discussing procedures of the second order. And this trend has been reinforced. Even more procedures about procedures. And there are clear elements where there is a lack of legal remedies. I would predict that the issues will arise that the person will claim that his or her rights has been infringed, but the law as it stands does not provide for a legal remedy against it. So, for example, being subjected to the screening procedures may lead to the fact that you are mandatorily assigned to the asylum border procedure. And this asylum border procedure is by definition characterized by certain restrictions on your mobility. And there is a fundamental right that is infringed upon. That may be justified. But there is a substantive right involved in the decision to assign a person to that procedure. But the EU legislation as it stands does not conceive of that assignment as a reviewable act. So we will be discussing as to whether this is in line with the Charter of Fundamental Rights. Speaking of which, I have arrived at the Court of Justice and what I perceive as his forthcoming role. I would briefly like to reflect on a change in the role of the legislator as far as procedural rights are concerned, from which a certain new role of the Court of Justice emerges. Actually, when I started to work in the field of migration law, originally being an EU lawyer, so I've written a piece on what I called the Trojan horse of the EU legislator activating procedural guarantee without knowing that, by simply, even partly, harmonizing substantive immigration law. It activates, by constitutional necessity, the applicability of certain procedural guarantees, both in the administrative stage of procedures, see Article 41 of the Charter, and in the legal protection stage, see Article 47 of the Charter. Whatever the legislator writes down in the legislation, whether it mentions the right to mount an effective legal challenge or something like that, even a shallow harmonization has led to deep proceduralization by means of constitutional law. So the EU legislator actually activated procedural guarantees by implication. And it was for the court to speak out, to make that clear in the relevant cases. So procedural guarantee emerged as a corollary, as a Trojan horse of incomplete harmonization. The new role of the EU legislator, in particular in the terms of asylum law, is a different one. Now it's the legislator itself that imposes restrictive concepts of procedures, either in the form that it enables the national legislators or the national administrators to use restrictive concepts, And sometimes it even mandates that. It obliges the member states to apply restrictive procedural rules. So it's not about filling gaps anymore, but rather the courts, and now I arrive at the point, will have to address these pieces of legislation that fail to accurately implement the fundamental rights that are part of EU law. So there is a tension between the layer of constitutional law being activated by being subject to EU legislation on the one hand, and the actual scope of the rights laid down in the legislation. And in an earlier piece, in an earlier article, I called it an under-inclusive legislation. And there's a particular strategy which the Court of Justice has developed in the past of how to deal with under-inclusive legislation. And I will predict that it will continue doing so. The main point is the Court of Justice almost never will nullify the piece of legislation. Whoever the one who challenges it, the action will not be successful on the merits. But rather, the court will find ways to come up with an interpretation of the terms of the legislation that at the end of the day is in conformity with EU fundamental rights. But this type of consistent interpretation actually oftentimes involve almost a complete rewriting of the piece of legislation. So sometimes even to an extent that it blatantly contradicts the wording of the legislation. Sometimes the legislation reads, member states may, and after construing this may in the light of fundamental rights, its actual meaning is may not. Because the general idea is member states, when implementing EU legislation, be it directive, the same applies to regulations. They must adopt a reading of the EU legislation which is in line not only with the wording of the legislation, but also which is in line with the higher law of the EU legal order, with constitutional law. And that may imply things like identifying exception clauses where the legislator have not written down any of them. There's a hard and fast rule without exception, but fundamental rights require to insert exception clauses, because otherwise that will lead in specific cases to violations of fundamental rights. Exception clauses, proportionality requirements, creating the discretion to adopt measures at the national level that are in line with EU fundamental rights. And this will happen with EU procedural law as well. And the same goes otherwise if wherever the European legislator has provided for discretion, sometimes even very broad discretion, member states may. Fundamental rights will require to use that, to exercise that discretion in line with fundamental rights. That's a general approach which the court has developed in the past, and I will predict this is what is going to happen. So, step by step, on a case-by-case basis, over an extended period of many years to come, the case law of the European Court of Justice will rewrite parts of the EU legislation as it stands. So it will apply this method of dealing with under-inclusive legislation also with regard to the procedural restrictions that are part of the law as it stands. On a final note, the court cannot do that alone. The court needs support. The court needs support from you in this room. Because these case law that has to be built over years, that must be a joint enterprise involving numerous actors, including legal scholars, PhD students writing pieces, identifying the issues, and making proposals of how they can be rewritten in terms of fundamental rights. It needs social civil society actors, NGOs, supporting claims making at the national level, and of course it needs national judges that have the courage to bring the respective cases strategically to the European Court of Justice. Otherwise, it will not be able to undo the procedural restrictions, at least partly, that are in the law as it stands. Thank you.
Thank you very much, Jürgen, for highlighting, the dark side of the procedural reform in terms of this new path of embedding procedure into procedures, which was already there in some places in the previous legal framework, but that now has been institutionalized and generalized in this seamless approach as described by Article 3 of the ADIM-IntoME regulation. So this is really, really leading us to the next speaker, who is going to deal with a specific feature, a specific aspect that has been pointed out as a major novelty in the reform, which is the legal fiction of non-entry. I have the pleasure to give the floor to Professor Philippe de Beaucaire, Université Libre de Bruxelles. Philippe, you have the floor for your presentation. Thank you very much.
Welcome, everybody. Nice to be here, and especially I am very grateful for the invitation sent by Mario, because a few months ago I saw on the internet how big the Academy of Migration Law was. I'm myself a networker when I created the Odysseus network, and I said, well, I am a networker, I see another networker in Italy, what are we going to do together? To network. And I'm really happy to be here, and I'm sure that in the future we will have many occasions to work together, and really thanks a lot for this very nice invitation, beautiful city, beautiful kitchen, very hot weather, but even as a Belgian about this, I cannot complain because it's also very hot in Belgium. So, indeed, I'm going to try to explain that the fiction of non-entry is a fiction, meaning by that actually it is a useless concept, but a dangerous one because it creates fog. It makes things much more complicated than what they are. And I put on the screen here two quotations, one from a senior lawyer, academic colleague, Valsamis Mitsilegas, and you can see that he says that actually the fiction negates the applicability of law to third country nationals and tolerates unchecked states of arbitrariness. Not least than that. Then I choose another quotation from Francesca Rondina. Maybe that Francesca is here? No? Yes? So, and here you see that she says that actually people under the fiction of non-entry are not refused access to territory, but also access to law. So actually these two quotes are very alarming. And I would like now to see if this is really the case. Where is the fiction of non-entry coming from? From the US. And it has been invented for a humanitarian purpose, because migrants arriving in the 19th century in the US on boats had one need arriving in the US is to leave the boat because of diseases and the risk to die on the boat if they were obliged to stay there. And the fiction of non-entry was invented in order to give them the possibility to leave the boat physically while not having been authorized to enter the United States. So that's actually where it comes from. Now, I think that the big difference is that in the US, this fiction is nowadays still applied. I put here one of the basic cases. You see a very old one, Ping. And in the US, actually, it is applied to deny to migrants basic constitutional rights, to really deprive them from basic constitutional rights. And we will see that actually this is not at all the case in the EU law. Now, examples of the fiction of entry in the regulations. Well, you have the screening regulation. You see it's clearly said that person shall not be authorized to enter. That's the fiction of non-entry. People will be physically on the territory, but they will not be authorized to enter, and legally they will not be on the territory. So a difference between law and practice. The same about the asylum procedure regulation. You see exactly the same type of sentence. Applicants shall not be authorized to enter the territory of member states. And actually, you have also in the return border procedure exactly the same type of sentence. So actually, we see really that legally the fiction is there. And even further, because you have old provision of directive of 2013-32 that has been now given an interpretation by the Court of Justice in a case Danae, where the court says that people, migrants and asylum seekers, may be put in centers on the territory, really on the territory, not at all at the border, not near the border, but far away on the territory. And even in that case, the fiction will apply and they will not be presumed to have entered the territory. So you see that it goes very far, this fiction. Now, question, that's the main purpose of my presentation. Are people really falling out of the law when they are subject to the non-entry fiction? And I have to say that I think that the statements that I put on the screen are really exaggerated, and that actually the non-entry fiction is a kind of myth that has to be debunked, and this is what I will try to do. Very quickly, because that's well known. First question, are people under the non-entry fiction falling outside human rights law? And there the answer is very easy, really very easy. And you can find it already in an old case of 1996, Amur, where an asylum seeker was detained in the transit zone of an airport. And the question was, can he rely upon the European Convention of Human Rights? And the court was extremely clear. You see point 52, the international zone does not have an extraterritorial status. In the zone, migrants are on the French territory, so the European Convention applies simply on the basis of the notion of territorial jurisdiction. As simple as that. And I think it's the same also for the EU Charter, but then the criterion is of course different. It's not territory, it is implementation of EU law by member states, but there is no doubt that at the border, member states are implementing EU law, screening regulation, asylum procedure regulation, and so on. So the Charter will also apply to asylum seekers and migrants under the fiction of non-entry. So my first conclusion is that there is no legal gap regarding human rights. Then of course you may say, okay, that's about human rights, but maybe if you think about secondary law, the directives and regulation, maybe there that actually there is a legal gap. And no, it's a bit different. What is true is actually that regarding persons at the border under the fiction of non-entry, the special rules will apply. Specific rules, but not necessarily linked to the fiction of non-entry, just specific rules, like you can have specific rules for procedures taking place on the territory. And let's have a look at the asylum procedure regulation to see how this works. So actually, the asylum procedure regulation, when you read it, it's a nightmare. You really say, God, either I'm stupid, either I do not understand anything, but you can read that. It will take you several days. It is so complex that actually you may give up. I tried to make up myself my mind, and I said, well, let's look at following two ways. What are the procedural guarantees, and what the types of procedures? And then you cross both, and then you see that actually it provides you a good understanding of the Asylum Procedures Directive, and what you discover is a bit strange. It is that actually all procedural guarantees apply to all procedures, to all different types of procedures, which is something strange, because if you say, well, there are different types of procedure, it's maybe because there are different procedural guarantees that apply. Well, mainly the answer is no. Of course, you have, and we will see that, some specific provisions, but the rule is nevertheless that procedural guarantees apply in all procedures unless there are some explicit exceptions that are foreseen. Now, what are the exceptions under the border procedures? I've put 4 of them. I've listed the 4 of them. I don't think that there are others, and I propose to review them quickly. So first of all, the time to lodge an application. Under Article 51.1 of the Asylum Procedures Regulation, asylum seeker will have 5 days to introduce their asylum claim. 5 days is short. Compare that, of course, to the 21 days that you have under the normal procedure. I wonder if there is not going to be a legal problem there, because you have, I put it also on the screen, an old case, well, not that old, IM from 2012, where actually it was about 5 days given to an asylum seeker to prepare an application, and the court said that actually the applicant was impaired and was not able to demonstrate the merits of his claim under Article 3 of Convention because the 5 days deadline was too short. So that's a question for the future, and maybe a problem will come up there. Second exception, the length of procedure. It's well known for the border procedure, 12 weeks, compared to the 6 months under the ordinary procedure. On top of this, it is 12 weeks, including the level of appeal, which is, of course, very surprising, because it takes in general years for member states to apply the first administrative procedure and then to deal with the judicial phase. Here, this will have to be done in 12 weeks. Realistic or not? Well, I don't think so. I have doubt, but the future will tell us. Within the next year, we will see if member states are able to do this. And I wonder once again if it's not going to be considered as legally problematic, even in law, because it will be considered too short. And in fact, of course, you may imagine that those procedures are not fair enough for applicants because they are done too quickly. Another question. The next point is about the deadline to appeal. Here, member states have to make a choice. to define the deadline to appeal for applicants between 5 to 10 days. So they may, for instance, say 7 days, but they can also say 5. Once again, when you look to the case law of the Court of Justice, you find some cases, in particular one where the court says that 5 days is too short. But it depends upon the circumstances. The court has not said that in an abstract way. The court said under the circumstances of that case, 5 days was too short. Think of people that are going to be in hotspots, maybe under difficult circumstances. Maybe that the court could also say, in those circumstances, in particular if people have detained, if they have difficult access to legal assistance, etc., 5 days is too short. If everything goes well in hotspots, no. But if the situation is bad, it may be too short, and you see once again a question. Now, the right to appeal, and actually subject to the border procedure, it is said that people do not have the right to remain. So then, of course, the question is, if they appeal, is that appeal suspensive? And the answer is no. But once again, it's complex because what is said in the regulation is that the appeal as such is not suspensive, but the asylum seeker have the possibility to ask the court to suspend the first decision. So you have to act in a second time to ask suspension to the court. Then you may ask, is this act for suspension, you request suspension, suspensive? And the answer is yes. So actually there you may say, well, is that system in line with the notion of the effective remedy? Is it not too complicated? Legally, I would say no. But in fact, it remains to be seen. I'm afraid that it will lead judges to have the obligation to look 2 times at the case. First, regarding suspension. Secondly, regarding the substance. And it will make the procedure more complicated. But again, the question here, will that be considered as in line with an effective remedy? And then, the last point is restriction of liberty. And here you see a key provision, Article 45(1), saying that member states shall require applicants to reside at the border or in proximity to external borders as a general rule. And you see that this provision said that it is on the basis of Article 9 of the Reception Conditions Directive, the only instrument that remained a directive in 2024, and this provision being about restriction of freedom of movement. So the emphasis here is put, member states have to use restriction of freedom of movement, not detention. They may use detention because it's without prejudice to detention, but actually it seems that they are advised by the legislator to restrict only the freedom of movement. Now, when you read very carefully all the instruments, I found a provision, 5.2, under the return border procedure that speaks about persons who were detained during the asylum border procedure. And here I'm afraid that the legislator used the wrong word. He should not have said detained, because here you see actually maybe the truth, what they really have in mind, suddenly popping up. Now, measures about the Reception Conditions Directive. The directive is much more complicated than the one of 2013. Now you have 3 provisions about the possibility of asylum seekers to move. Article 8, you can allocate them to a geographical area. 9, you can restrict their freedom of movement. And 10, you deprive them of their freedom. And of course, that's an increasing scale of measures taken about asylum seekers. Now, you can compare those three notions. I put them on the screen. I don't have time to elaborate about all the differences, but it's clear that allocate asylum seekers to a geographical area is very easy. Member states do not even have to take a decision about that. This is said under Article 8.4 under the Reception Conditions Directive. What Jürgen says also about the screening regulation, you are channeled to a procedure, but not on the basis of a decision. Here, you should be restricted to a geographical area, but just like that, without a decision of a member state deciding this. Then, of course, it's more demanding to restrict freedom, and it's even more demanding to detain, to deprive people of their freedom. And the big difference is, again, about individual assessment, which is not required for allocation, not at all, not explicitly required for restriction, but well for detention. And that's an important point. I will come back to this in a while. So actually what is very interesting regarding detention is to look at the famous case, FMS, of the Court of Justice of 2020 about the transit zone near the Hungarian border. And here you have a very clear statement of the court saying that detention cannot take place without checking necessity and proportionality of the measure, and that it can be applied only as long as the ground on which it is ordered continues to apply and the procedure is carried out diligently. So you have a strong requirement already in the case law of the court. Now, what can you conclude about this? Well, contrary to what is often assumed, it is not easier to detain asylum seeker at the border under the non-entry fiction. Actually, the same rules apply regarding detention, and you have them in the Reception Conditions Directive. Now, of course, we will see that there are some difficulties, because I think that there you have a real nest for legal disputes in the future. For instance, if member states say, well, we don't restrict the freedom of people, we just allocate them in a hotspot to remain in an area without any decision. It's like that. Is the judge going to accept that it is just like that without any decision? Now, about restriction and deprivation of freedom, the problem will be where is exactly the different? And that's not always that clear-cut, because the Court of Strasbourg said that it's a difference of degree and not of nature. And then I think that the biggest issue will be, can restriction be imposed without an individual assessment? An individual assessment is required for detention, but not explicitly for restrictions. What will the court say about that? Will the court say that there is a need for an individual assessment? If it is detention, then, of course, the guarantee that I have quoted will apply, necessity, proportionality, including a check of alternatives to detention. But then, what is the judge going to say? If actually detention, the procedure takes longer than the 12 weeks, will the judge says, no, after 12 weeks, detention is not anymore possible? I think that that's something clear. And the judge will also have to say, well, there is a need for an individual assessment, and you must, of course, then apply it, which would then prevent states just to detain everybody. So there the court will have a crucial role to play to avoid de facto detention, meaning a measure restricting freedom, which is actually a measure for detention, and also will have to play a key role about blanket detention by saying, no, you cannot detain everybody because just people arrive and they must be checked if they have the right to enter. You must do a case-by-case assessment. So these will be crucial issues for judges to solve. Now, my general conclusions is that actually you have, as you have seen, special provisions for border procedures, and that they can really lead to legal problems. But this is not due to the fact that people under those procedures are under the fiction of non-entry. These are just simply specific procedures for border procedure. And then I come to my conclusion, which is actually that the concept of legal fiction is void and useless. It's a pity that it has been included in EU law, because it feeds the imagination of students, NGOs, that it is a worse situation than a normal procedure. And people think that it can be used to curtail human rights. I think that this is not the case, but it's very unfortunate that such a concept is used under EU law, because with the discussion that I already have with students, PhD student research, they feel very uneasy, and that's logical with such a presumption. And even an official from the Commission told me what a pity that it has been included in the EU regulation, because it's absolutely useless. And I hope that you are convinced, quod erat demonstrandum, we are in Italy, Latin is necessary. Thank you.
Thank you so much, Philippe, especially for, this very clear statement about the legal fiction of non-entry, that it's a void and useless concept. If you may accept a provocation, I do agree. I do agree on the premise, on the nature, which doesn't change, on the fact that we are dealing with the creation of a special border regime, which in fact doesn't change the jurisdiction, the relationship between the jurisdiction of the member states, territory of the European Union, application of the laws, the Charter of Fundamental Rights. But can we ask ourselves whether this narrative may, in the long run, affect the evaluation by judges? Because of course, you mentioned a lot of case law. You quoted FMS and other cases, which are leading cases, taking into account the previous legislation. But then, when the law changes in a way, the judges are also in charge of limiting the hiatus between the law in the courts and the law in practice, we may say. So this could be, a question for the debate, but it's also a bridge to the next presentation. And I have really the pleasure to give the floor to the organizer, the ADIM conference, Professor Mario Savino, who will deal with the presumption of safety, which is another cornerstone of the reform. So, presumptions of safety, safer countries, and the role of the judges. Mario, you have the floor. Thanks.
Thank you very much, Daniela. Many thanks for his kind words to Professor De Brucker. Many thanks to Jürgen Bast, who is at home now, very frequently here in Viterbo. We are very glad to become an increasingly international community. And we are glad that this migration conference helps this university in this respect. Now, my topic is related to the hot topic of safe countries of origin. We mentioned it earlier. Peter yesterday was addressing the issue from the British perspective. I will do it from the European perspective and also the Italian one to some extent. But I will focus on the European legislation, and especially the very recent regulation 464 of February 2006. So my focus is specifically on safe countries of origin. I will leave aside the issue of safe third countries, which was also mentioned in the last sessions, because different problems emerge from those two different notions. So my question is, what do the new rules adopted at EU level and concerning safe countries of origin, what do these rules tell us about the separation of powers in the realm of asylum law? So the focus is on the separation of powers, and in particular on the distinction between rule making and rule implementation and adjudication. I anticipate my answer, which is that the new rules adopted at EU level embody what theorists of law call the rule-based model, a model of separation of power which rests on a very simple assumption, which is the following: those who make the rules cannot apply the same rules to the individuals. And by contrast, those who apply rules to individuals cannot make the rules themselves. Just the very basic foundation of the separation of power. Let me add a clarification. My argument sometimes has been criticized for not for excluding judicial review over rules. Quite the contrary. In my view, rules must be subject to judicial control, but to the appropriate judicial control, which is not the control carried out by lower courts, asylum courts, but by constitutional courts, where there is constitutional adjudication in place. The point is not to shield rules from review. The point is to distinguish who makes the rule, who applies it, who reviews the rules, and who reviews the way rules are applied. Now, my starting point is Regulation 464 of 2026, which concerns, as I mentioned, safe countries of origin. And the regulation does two things that are quite interesting and important to my argument. One is it establishes a European list of safe countries of origin. So far, we had only national lists that were disapplied, set aside by national courts, in particular in Italy. This regulation makes the list European. And the very same countries that were on the Italian list become European, become part of the European list. Bangladesh, Egypt, Morocco, Tunisia, India, Colombia, Kosovo. What is the institutional implication? I just mentioned it. So far, national designations were set aside by national courts. From now on, from 12 June 2026, national courts will not be allowed to set those designations aside simply because they are part of EU law. And national courts cannot set aside EU law. They can only refer doubts about the validity of those designations and their arbitrariness to the ECJ, just like national courts could have done with national constitutional courts. So this is a first element where I see the contribution of Regulation 464/2026 to the rule-based logic. National courts assess only the individual case, cannot review the general assessment on which the adjudication is based. And if they have doubts, it is for another court to assess those doubts. Now, the second element of innovation related to that this regulation introduces is related to the Alace ruling. In Alace, the Court of Justice relied on, I would add, heavily relied on Article 47 of the Charter, the right to effective protection, and gave it a very expansive reading to the extent that for the Court of Justice, the role of national asylum courts cannot be confined to the individual assessment. In each case, those courts, national courts, should also be empowered to assess whether the country is safe as such, in general, not with regard to the individual and his specific reasons, but in general. And if they are convinced that the assessment, the general assessment made by the legislator is wrong, they can simply set aside the national legislation, as the Italian courts did. So, as you can see, here there is a shift, a clear shift from the rule-based model. The ECJ held that national courts no longer asks only whether the country of origin is safe for that specific applicant. They may also ask themselves if the country is safe in general, and to the extent that they deem it unsafe, they set aside, they rewrite the general assessment made by the legislator. So the judge moves from applying the rule to the individual to reassessing the rule itself, which I find particularly problematic. My point is not that judicial review is unnecessary. Let me restate it. Of course it is necessary. My point is, first, judicial review cannot become judicial substitution. If the rule allocates the power, if the European rule allocates the power to national authorities, it is for the legislator and the government to make the general assessment. Second, this specific kind of judicial review over legislative designation belongs to constitutional courts. Now, what is the crucial, and here my argument becomes a little bit more technical. What is the crucial point that Alace seems to miss? The relative nature of the presumption. When the notion of safe country of origin is introduced, there is a presumption that stems from it. The presumption is that the asylum application is unfounded. But this does not mean automatic rejection of the application or the lack of judicial control. It only means that the legislator makes a general assessment applicable to classes of national asylum seekers, and then secondary decision makers, administrations and judge can still make at that point the individual assessment. They can still ascertain whether the third country is safe for that specific applicant. Now, this relative nature of the presumption is essential, and yet the ECJ in Alace simply overlooked it. And this is where I find a second contribution of the new regulation 464/2026, because this regulation makes the relative nature of this presumption more visible. In particular, they introduced some correction mechanisms that are very relevant. First, territorial and personal exceptions are admitted explicitly, which means a country can be safe in general, but it can be unsafe for specific categories or in specific areas. Now, we have, of course, the critics here too, and critics say, well, this is another way for the Leviathan state to be able to manipulate the designation of safe countries. They can designate countries that are unsafe. They can say that they are still safe, but there are exceptions to it. I read this again differently. those exceptions are defeaters to the general rule. This is the way philosophers call this exception to the rule in the context of the rule-based model. I mean, when there is a territorial or personal exception, those defeaters are just correction devices. They are safeguards against the over-inclusive nature of the presumption. This is very important. I mean, rules simplify the reality, right? They may well be over-inclusive, and therefore any serious set of rules should have its own exceptions, its own defeaters. And territorial and personal exceptions, exactly those ones that the court rejected in Alace, exactly those exceptions do this. They preserve the rule and at the same time prevent the rule from becoming blind. So let me just reframe quickly before I close that the logic of the new system, it's a three-level system. First, there is the general presumption. So the legislator makes the general assessment concerning the safety in general of the third country, and it applies it to classes of applicants. So general and abstract. And this rule embodies a legislative balance between the criteria established under Article 37 of Directive 32/2013, and I don't remember exactly the number of the new regulation 1348/2024. Second level, territorial and personal exceptions. The rule recognizes that the country may not be safe for everyone. Some areas may be excluded. Some categories of people might be excluded, and this exception corrects the presumption already at the general level. Third level, individual assessment. Even outside those exceptions, the applicant may still rebut the presumption. Even if they do not belong to the personal categories that are exempted from the presumption, they can still say, well, if I go back, I will face a specific risk. This country is unsafe to me for specific circumstances, and so forth. And in such cases, both the administration and the judge will exempt him from the special procedure. This is the core of the model. The applicant is protected, and this is my key point, is protected not by abolishing the rule. It is protected by applying it with exceptions. Justice in the individual case does not require any judge to remake the general rule. It only requires the judge to do its own job, his own job, individual assessment. Now, will national courts follow this rule-based model that the new regulation offers and promotes? I think it depends very much on the attitude of the Court of Justice. If the Court of Justice accepts this approach and does not overlook it, then national courts will follow, and rules might remain contestable but still stable, and procedure might remain workable. The other scenario is not judicial compliance but judicial resistance. ECJ and national courts will might continue to follow the Alace logic. Courts may keep reassessing designation themselves, multiply preliminary reference to the ECJ, suspend or de facto neutralize border procedure. The result would be that ordinary courts become the place where the general policy is reopened. A new institutional conflict at that point is unavoidable because political powers will not stay there and accept it. And the problem and the institutional conflict will arise very likely from the national level to the European level where these rules are now established. So what is at stake here? First, separation of powers. Second, the idea that a legal order is based on rules and that courts cannot reopen the balance on which those rules rest. Third, judicial credibility. If courts control power, they remain credible. If courts exercise the decisional power allocated to other institutions, they become much more exposed. When courts move from controlling the game to rewriting the rules of the same game, the credibility of adjudication is exposed to backlash. And this is my final point. The fourth risk is judicial independence. Judicial independence is strengthened when courts use their power with attention to the separation of power and to the institutional setting. Judicial review has limits. If courts use their power without considering those limits, they give the impression of using an unlimited judicial power. And this means just one thing, that courts can contribute themselves to their own cause, independence, by protecting rights firmly in the case at hand, but also by respecting their institutional limits. Otherwise, they make it easier for political actors to attack them as political powers. Thank you.
Thank you very much, Mario, for your thought-provoking presentation on the future of litigation in the field of asylum in the aftermath of the new pact. I think we could just make a question to you, which is, are we sure that courts are exercising powers allocated to others when we look at the constitutional order of the European Union? Are we sure we can apply the separation of powers as we are used to study and apply it in the national level when we move to the supranational level? So those are very big questions that we may leave for the discussion, but that your representation raised. In my opinion, it's now time to move to our last speaker, last but not least, Francesco Gatta, University of Palermo, who will introduce another aspect of what we are looking at, the Chisinau Declaration, the new political and legal statement by the 46 states of the Council of Europe about, the new approaches to migration, asylum, border management, which may turn key principles such as the principle of non-refoulement in wishful legal thinking, if I may quote this. So, Francesco, you have the floor. Thank you very much.
Thank you very much, Daniela, for the kind introduction. Let me just use a few seconds to thank Professor Savino and all the other colleagues and organizers of this conference for the invitation. Thank you very much for having me. So in these last minutes of today's conference, I would like to discuss a little bit this very fresh document that was released a few days ago, really, the Chisinau Declaration, which is a political document. So a first question that arises is, why do we need to discuss it? We have been listening to such brilliant presentations about EU law, about procedures, about rules, about legally binding instruments. So why do we need to address a soft law act and a political declaration, which, by the way, is coming from another international organization, the Council of Europe. So at the first glance, it might sound irrelevant, but I think it is, on the contrary, relevant and directly related to the AU Pact, as I will try to show. The Chisinau Declaration is just the tip of the iceberg, is part of a process of a mounting pressure on, in particular, the European Court of Human Rights. And it came at the end of a process. That's why I use the expression Chisinau process. It's not just a declaration. It's a process made of different steps that have been made in the past years. And why it is related to the pact? For a number of reasons. First of all, again, the origin of this declaration, it didn't come out of nowhere. It builds on previous political acts and soft law acts and statements that align themselves in a way of putting pressure on the European Court of Human Rights. Secondly, the timing of this declaration, I think it's not a coincidence. It has been released exactly a few weeks before the full application of the AU Pact. It has been published and disseminated while the return regulation, the new return regulation, is being negotiated in Brussels. It has been released while there are important, crucial issues pending at the European courts, including the Italy-Albania protocol and the prospect of return hubs in third countries, the instrumentalization litigation that is pending before the Grand Chamber of the Court of Strasbourg. So the timing is quite telling, I think. And the overall objective seems to me to put pressure on, in particular, the European Court of Human Rights and try to make things clear as states would like, the directions they would like to have from the court in the implementation of the new rules. And so there is a dual aim, essentially, a dual goals behind this declaration and this process. Probably one objective is genuinely political, is purely political, to externalize, so to say, responsibility for migration-related challenges that states, governments are experiencing domestically. European Court of Human Rights as a scapegoat, in a way, for pressures at domestic borders. But more importantly, there is a legal, I think, goal, a legal objective, which is trying to, so to say, protect the implementation of the new rules and the way in which they will be applied. It is clear that there is a general overall political consensus in Europe on the directions of new European governance, migration governance. This political consensus has been addressed on the adoption of new rules, and now there is a need, so to say, to protect these rules, which are based on keywords that professors before me have very well presented. The keywords are immobilization, removability, detention, acceleration of procedure, procedural restrictions, and so on. So the aim is to get the green light from Strasbourg on the application of these procedural standards. And the Chisinau Declaration, of course, comes from the Council of Europe. So it has been drafted, negotiated, and signed by 46 member states, including all the members of the European Union, of course, and also by other crucial actors, including the United Kingdom, Albania, Turkey, Serbia, and other countries that are strategic from the point of view of migration management. So why is this declaration and this process in general targeting, so to say, the European Court of Human Rights? Why do states fear, so to say, the Court of Strasbourg? Well, from their point of view, this preoccupation, this concern might sound understandable because, as a matter of fact, over the years, the European Court of Human Rights has influenced the application of rules of the common European asylum system, more generally of EU border law, EU asylum law. This is just a non-exhaustive list of landmark judgments, leading cases by the Court of Strasbourg that have influenced the application of migration law and asylum law in the EU and beyond. Let me just mention, for example, MSS against Belgium and Greece, Grand Chamber of 2011. We all know this judgment, which destroyed the presumption of common standard level of human rights compliance in the Dublin states. We have a number, countless now, judgments, decisions on reception conditions in hot spots in Greece, in Italy, in transit zones, in Hungary, and elsewhere. We have important decisions concerning the situation of reception of asylum seekers in Belgium, for example, in Malta, and these are also decisions where the Court of Human Rights has involved Article 46 of the European Convention of Human Rights, which is about general remedial measures pointing to problems that are not episodic, that are not isolated, but that are potentially widespread and systemic. Search and rescue operations in Greece, interception of migrants, age assessment of minors, procedural issues, procedural aspects. More recently, even so-called para-Dublin arrangements between member states of the EU, Germany and Greece in this case, for fast-track transfer of asylum seekers. The UK-Rwanda deal has fallen under the scrutiny of the Court of Strasbourg. So from this point of view, we kind of understand why there is such a concern for the scrutiny of the Court of Strasbourg. Now, the Chisinau Declaration and the other acts are all, they have a common denominator. They built on three, I think, recurring topics, argumentations. First of all, the crisification of migration-related procedures. We live in a time, states say, where there are unprecedented challenges, new unprecedented challenges and problems in migration management. Secondly, and consequently, we need to change the rules. We need to actually reinterpret the rules on human rights protections. They are obsolete. They don't work anymore. We need to have a fresh, new interpretation of those rules, including especially the European Convention of Human Rights, of course. And finally, states need to experiment new approaches. This is how they are called in the Chisinau Declaration, new approaches. In the draft, the term was innovative solutions. The final draft, we have new approaches, including return hubs, response to externalization, to instrumentalization, and so on. And I will now briefly go through these precedents to show you how these are recurring argumentations. This is a communication by the European Commission released in December 2024, just before Christmas, where the European Commission, first of all, highlighted that The security environment has changed. There are new unprecedented challenges for border controls and migration management. Secondly, member states need to explore new solutions and adopt measures that could entail serious interferences on fundamental rights, including right to asylum and procedural guarantees. And thirdly, there is a need for a new thinking of the interpretation of the European Convention of Human Rights. The famous letter of the 9 governments, one year ago, May 2025, an initiative promoted by Italy and Denmark for an open letter that has been signed by 7 additional states, for a total of 9 member states of the EU. Once again, unprecedented challenges and difficulties. Secondly, the convention has been extended, its interpretation has gone too far. The European Court of Human Rights has overstepped its boundaries in protecting the wrong people. This is what we find literally in the letter. And states need space of maneuver for new solutions, new approaches. December 2025, a joint statement by 27 states, so from 9 states, 27, endorsement of 27 member states, joint statement released in Strasbourg at the Council of Europe of Human Rights Day, by the day, curiously, 10 of December, same narrative, same logic. And finally, the Commission's declaration statement on the Chisinau Declaration 10 days ago or something like that, where the European Commission from Brussels endorses the Chisinau Declaration, is happy with this declaration, which the Commission says addresses key topics of the EU migration management, illegal arrivals, instrumentalization, returns, and externalization. So the conventions need to be interpreted in response to these challenges, and the Commission is very much happy with this approach. We are aligned, the Commission says. So to conclude, just quickly, an overview of the main points of the Chisinau Declaration that I think are relevant for the new pact that connect with the EU pact. Borders control, which states shall be allowed to perform border controls on selected categories of migrants. Expulsions, the threshold of Article 3 of the severity of ill treatment shall be watered down, and there shall be caution exercised when applying the case law of the court. Mass arrivals, instrumentalization. I have compared here the definition of instrumentalization under the pact with the notion of instrumentalization in the Chisinau Declaration, which is broader, it has been extended in a way. Again, soft law, political declaration, yes, but still a signal of extending the definition of instrumentalization so as to encompass more cases in which states can react against instrumentalization. And finally, the new approaches, the so-called new approaches, and I'm concluding here where the Chisinau Declaration points to the importance for states to pursue new approaches to deter irregular migration. And among these new approaches, the declaration encompasses externalization of asylum procedures and return hubs, which are explicitly mentioned in the declaration. This declaration builds a lot on the logic of crisification. It kind of addresses the future jurisprudence of the Court of Strasbourg by warning, in a way, the Court of Strasbourg, and it calls for guidance, for clarifications. But actually, I think rather than a genuine way of a dialogue and waiting for the guidance of the Court of Strasbourg, the signatories of the Chisinau's Declaration are expecting from the Court a number of judgments which would set narrower standards of protection of human rights and procedural guarantees, which will then be followed and could then be followed by domestic courts building on these precedents. I'll stop here because my time is up, but I will be happy to engage in discussions and questions. Thank you for your attention.
Thank you very much, Francesco, for shedding light on this risk of bifurcation between the case law and the law, which might be at the basis of this Chisinau Declaration. I would like to open the floor for questions, if any. So yes, I see Professor Motomura. And maybe we can collect 3 or 4 questions. There is another question here. And then start. Thank you.
So thank you for this wonderful panel. I mean, every presentation prompts many questions in my mind. But I'm going to focus both my question and my gratitude to Mario. And I have a question for you. But first I want to comment on the connection between the question you asked me yesterday about group versus individual determinations and this topic, because after all, a safe third country determination is a group determination, right? So I think you and I agree fundamentally on some of the need for a balance, but I just wanted to comment on that. But here's my question for you. You posit basically 2 models of judging. I think they're very valid empirically. One model is Judge A. Judge A says, you have safe third country determinations, but I don't care. I will make my own determination. And this you criticize. And I think you're persuasive in your criticism. Judge B says, I accept the safe third country determination, but I find an exception. What is actually the difference between those 2 judges? And will the effect of your criticism, as you convince people, will the effect be that people who would have been Judge A decide that it's better for their own reputation or for their own advancement to become Judge B, but it really doesn't matter? Or does it matter in the long run how these judgments are articulated if they end up in the same result? Thanks.
Good evening, everyone. Thank you for this wonderful presentations. And I'm just, for me, this is great pleasure to listen to brilliant people speak, the people who I really look up to, and read their articles to speak about the issues that I am working with, because I've been boggling my mind on the topic of how the EU Pact, and especially the procedures regulation, reconciles with the fundamental guarantees that the EU Charter has to offer, especially the right to effective judicial protection, which would be Article 47. And based on your presentations, I realized that maybe I'm not that crazy, because there are some synergies that I find with my thinking. But I think my question would be addressed to Professor Savino more so than to other speakers. However, I would be very happy to hear everyone's opinion on this. Because you mentioned, if I understand correctly, that the exception to safe country of origins, so the territorial and personal exception, in your thinking sort of helps the individuals, because it can be used to prove that in the individual case of that specific applicant, that specific country or part of it is unsafe. I get that, and I agree with that. But what I'm wondering is, if you take that together with all the procedural restrictions that were spoken about by, for example, Professor De Brucker, if you take the fact of the border procedures that last for 12 weeks, 5 days that you have to lodge in, 5 to 10 days, okay, but let's say 7, that you have to prepare your case. then 5 days for another appeal, no suspensive effect. So all this system of a restricted procedure, starting from screening all the way to the return if it's manifested, and that has no interim measure, no suspensive effect. So the courts have this burden to decide again on the validity of the decision of the suspensive effect, which is another concern to me. So if you take this whole system together and the exception, are we sure that the exception can actually be attainable in practice? Because I understand that on paper, legally speaking, maybe there is no contradiction between the essence of the right to effective remedy and the designation of safe countries. However, I fear that the fact that there is no general designation, which the court called for in the CV judgment, for example, which Alache was heavily based on, there is going to be an increasing number of individual applicants who might be sent to the country that is unsafe for them even before they can reach the genuine protection under Article 47, before their individual assessment might come into play and might be materialized in practice. So I question, and this question is much more general, I wonder how can we find legal ways of arguing, of saying whether the guarantees that on one side the individuals should be part of is actually part of the EU legal order in the secondary level, but if we exclude the role of judges as reviewers of this designation, then who is there left to protect those individuals who might be sent to the unsafe countries, generally speaking, before the individual assessment reaches them, or they attain the access to the court, which is heavily restricted by the procedure as it was demonstrated by the speakers. So this is my question. Sorry, I hope it wasn't too complicated.
Thank you very much. My name is Maria Bermudez from the University of California, Irvine. Great panel. I agree with Hiroshi. We could be asking questions all evening. Another panel that is not disappointing in a fantastic conference so far. I have a question. I try to be very brief to Philippe de Brucker, but anybody can answer. I think I don't understand, which is my way of saying that I slightly disagree with you. Regarding the way you have elaborated on the fiction of non-entry. I was surprised by your reference of Chai Changping. That is a case that is very far away. I do not think it's applicable. It was inside of the whole Chinese Exclusion Act, etc. And I was surprised because we have reference and precedents right here. So Germany has been using the legal fiction of non-entry since 2017. It was reflected in the Residence Act, I think Section 3. Correct me, Jorgen, if I'm wrong. It's called the fiction der Nichtenreise. Yeah. We had the same case in Greece, where we were applying already the fiction of non-entry in 2020 in the Evros border. We continue applying it through the fencing period up to the draconian period. Portugal has been applying the fiction of non-entry at the international airport for many years now. So has been Spain at the Madrid airport, but also in the enclaves in Melilla and Ceuta in Africa. So I see the pact as a consolidation of the political wills and the political practices that have been occurring for almost 10 years inside of the European Union member states. So this is a consolidation. I see no novelty. I see no contradiction to the political will and the political practice when it comes to certain loopholes, legal loopholes, such as this, the fiction of non-entry, that we have been practicing individually for a very long time. So I wonder if you could extend on that and maybe clarified my doubts about why are we treating this as if there was anything new, which brings back to what Jorgen was saying about what is new and what is not, and of course any of the panelists. Thank you.
First of all, thank you for all the insightful presentations. I have one question and one reflection. The first question is for Professor Savino. I mean, if the Court of Cassation itself holds the designation to be legally conditioned act, justiciable precisely because of Annex 1 of the Asylum Procedure Directive, fixes the criteria on what basis is alleged reviewability an intrusion rather than the orthodox review of a bounded power. Is the real objection the existence of the review or its intensity? And the second question, it is not properly a question, is more a reflection, is about the Chisinau Declaration. Because looking at what Marie Dembroux has said in the well-known paper of the Strasbourg reversal, and given the increased proceduralization of rights before the European Court of Human Rights, it was not just limited to articles such as Article 8 and Article 10. And I'm thinking about, for example, Attilias and Ahmed versus Hungary, where the proceduralization was touching Article 3, which was kind of something new for the European Court itself. Are we witnessing something that actually is not going against governments and member states of the Council of Europe? Because if we look also at the data that were published by the European Court of Human Rights itself, not so many judgments are going against governments, quite the contrary. And so my reflection would point in direction that maybe this is a way for EU member states and member states of the Council of Europe in general to double down on this political climate in order to get the maximum amount of income out of what is happening right now, given that the jurisprudence and the case law is basically denying what actually they are claiming. Thank you.
The microphone was off. Okay, so maybe we can address these first four questions. I will give the floor first to Francesco because he has a train to catch, and then to the other speakers.
Thank you, Daniela, and yeah, thank you, Ruggero. I will address your question and or observation, which is true. I mean, the Strasbourg reversal theory, I think, goes back to the book of Professor Dembour of 2015. I think it's more than 10 years ago, but it's still very, very much valid and today and applicable. And I would agree with you concerning the idea of the court as an adversary somehow of states and governments. And as a matter of fact, the court itself, the registry of the court of itself, published data and statistics and information sheets and papers to kind of counter-argue this narrative. And in the latest version of this data, which I checked, it's May, so it's most up-to-date. Indeed, that data tells us that in the last 10 years, out of the whole litigation in Strasbourg, the whole of applications brought to Strasbourg and cases decided in Strasbourg, 6% it's about migration. 2% it's about migration, and out of these applications, a violation was found only in 6% of the cases. So yeah, that's something, thanks for bringing this up, because it's something absolutely relevant. And also, I would say I agree that it's particularly, especially relevant and worrying Article 3, concerning, Article 3 and the lowering of the standards of the level of severity that is required for an ill treatment to trigger Article 3. That's especially, and the Chisinau Declaration is especially addressed this point, and it explicitly say that caution shall be used when referring to the case law of the court. But it's nothing new. Once again, it goes back to the 90s, early 20s, about the expulsion of terrorists or suspected terrorists. The UK, in particular, in that occasion, was extremely pushing for reviewing the standards of application of Article 3. So, yeah, it's something relevant that is, however, coming back in a way. Yeah.
Thank you so much.
That's it, okay. Well, I will be brief because I'm sure that other speakers will also have things to say, and there will be other questions. Well, I can understand that you're a bit shocked by my presentation, because I agree with you, of course, that the fiction of non-entry is part of a discourse, and you can say that, of course, it is the consolidation of bad practices that we have seen in the European Union in several member states. But my point is to say that it is a consolidation from the political point of view, but not from a legal point of view, because I really think that there is no problem with the fiction of non-entry, because the problem lies in the specificities of the rules applied to the asylum border procedure. And I want to be very clear about it. The broker has not said that there are no problems with border procedures. No. What I say is that we should forget the issue of the non-entry fiction, because it's not the issue. The issue are the specific rules applied to some border case. And I think that it helps to clarify the debate, because otherwise we could, I would imagine NGOs campaigning about the fact we want to abolish the non-entry fictions in those rules. You can do that, but that would change absolutely nothing to the rules that are applicable. So my point is just precisely to try to understand where the focus is, and the focus is on specific rules for some procedures, and in particular border procedures, but not from a legal point of view about this non-entry fiction, even if I understand that it's part, of course, of the political discourse, but I react more as a lawyer than to political speeches.
I would like to make a... Is that fine?
Yeah.
It's on? Is it loud enough? Okay. I would like to briefly comment on your thought, Kanta, and then jump into the debate on safe country of origin, if I may. So, okay. Just briefly, you mentioned Article 47, that is certainly of the Charter, and that is certainly one of the numbers to raise. So that's clear. But we should also reflect on the procedural dimension of substantive guarantees, including the principle of non-refoulement and its inclusion in the Charter, and even more specifically on the yet undiscovered implications of Article 18, the right to asylum in the Charter of Fundamental Rights, which, if taken seriously, also has its own procedural dimension requiring the procedures that the EU legislator has to adopt, according to this article, to meet certain standards. And then you can apply this consistent interpretation thing in making them complying with the standards which we can derive from Article 18. That could be one in addition to 47, we could go for 18. That's no contradiction among them. Yeah, that's right. Okay, just one reflection on safe country of origin. Well, with undergrad students in first and second semester, one of the first things I always say is, law is a different language. You have to learn a new language. Terms have different meanings. So in this context, for example, the term safe country of origin. So we should better use a number or an acronym. Otherwise, it gives the impression that this country has to be safe in the ordinary meaning of the term. Not even the legislator required is to be safe. So therefore, I find it important that you, Mario, brought into consideration the important element that the concept of safe country of origin as implemented by the EU legislator does not undo the right to asylum within the European Union on the basis of an individual application. So therefore, it's completely different from safe third country. We should never confuse the two concepts, because safe third country says no asylum within the European Union, and our assessment will not be on the merits, but only a general assessment of the quality of the asylum system of a third country. Therefore, I find it important that you mention that one. Therefore, I would say the real issue are the other legal consequences that are attached to this concept. Essentially, it's not only a procedural concept. It's about a social status. Look into the Reception Conditions Directive. Look into what the member states do with the designation of a safe third country. It's about identifying nationals whom we intend for political reasons to treat so badly that they do not apply for asylum. It has almost nothing to do with the safety of the country. So that is the wrong impression given by the name. It's about those asylum seekers whom we are not going to integrate during the procedural phase of during the administrative procedure, and we devise the asylum procedure itself in a way that it deters people from making use of that. So that's the substance of the concept. And now we can reconsider your claim, Mario, that the European legislator, or in this case, delegated the Commission, is best suited to identify the countries whose nationals we are, for political reasons, intend to treat so badly that they're not going to claim asylum. And I wouldn't say that this is a plausible allocation of powers. So therefore, I would hardly criticize that concept, but not for the wrong reasons. Not for the reasons that it undoes the right to asylum. You correctly say that's not the case. For other reasons, I doubt that it's even a constitutional concept. It's a misapplication of powers to make certain determinations, but for completely other reasons.
Shall we start another conference now?
Everybody like to tell me?
Okay, I will start with Jürgen. Problem of terminology. Perhaps the concept of safety is not the appropriate term. I don't know. Maybe we can find another substitute. What is clear now, also in the law, is that what matters is the rate of asylum recognition. Those who are below 20% will be countries whose national will be channeled through the special border procedure. Is it about treating those people badly, as you just said, for political reasons? I see the point, but I do not share it. I mean, this is a functional mechanism in order to make a distinction between asylum seekers who prima facie do not have any relevant claim to asylum, and those who, by contrast, might have serious arguments and therefore requiring the administration first and then courts to review them carefully under the ordinary procedure. And I go back to my point of before. This is just a relative presumption. This is not about people treating people badly. It is about individual assessment according to which, if there is a person that raises significant elements to induce the court to determine that that person might have a right to protection, then the special procedure is simply over, and it is channeled through the appropriate procedure which offers all the opportunities of defending that person's claim to protection. So I don't see why we need to use these, powerful words and adjectives like badly. This is functional to a purpose, and the purpose is to prevent secondary movement of those who claim asylum without having rights to it. We can find another way to do that, fine, but we cannot disregard the fact that the legislator at European Union level identified the prevention of secondary movement as a key purpose to pursue through legislation and administrative action on arrivals. Now, let me go back to Hiroshi. Thank you very much for your question. You said judges A decides regardless of the designation, and judges B decides by introducing an exception. So what is the difference? Well, let me reframe the alternative, because legally speaking, it is a bit different. Judges A decides on the designation regardless of the individual position. This is what happened in Italy, regardless. They just focused on the legality of the designation as such, in general, okay? So question is whether a lower court is entitled to shift the object of its review from the individual position to the law, to the legislative designation. Judges B decides not by introducing an exception, but by following the law that already provides for that exception. Because the law says there is a general presumption, but there is the possibility to exempt that person on the basis of individual assessment. So it's slightly different. And therefore, the two paradigms are, one, having a judge whose role is perceived as maximizing individual protection beyond the law, regardless of the law, and Judge B applying the law and perceiving the law as a limit to the protection of the right. That same law is required to adjudicate. Ruggero asked me about the Court of Cassation and whether the approach of the Court of Cassation about the intensity of judicial review is in the end what I try to your question, if I understood it correctly, is whether my argument is coincident with the argument of the Court of Cassation. Yes and no. Yes, my argument is judicial review cannot be understood as more than control of others' decision and the legality of that decision. When the judge steps in and replaces his own assessment to the assessment of another power, being it the legislator or the administration, then there is this substitution. And this is a sort of horizontal problem. The court reviewing the assessment of the administration by replacing it. I also stress another, and this is one problem I highlight. The other problem that try to stress is the fact that there is also a vertical problem, meaning lower courts, asylum courts, want to review not the individual position, not the assessment with regard to the individual by the administration, but also the general assessment carried out by the legislator on the general situation of that country. And this is the second dimension of the problem that the Court of Cassation does not acknowledge. Well, TAMTA, personal and territorial, this is challenging, and thank you very much for your question. So TAMTA says, okay, territorial and personal exceptions help individuals in the end, because imagine that there is an exception. Imagine that Tunisia is considered to be safe, but imagine also that there is an exception for lawyers protecting migrants because they are mistreated in Tunisia. Does this help the applicant? Yes. If he or she alleges to belong to that category, it is sufficient for them to say, I'm a lawyer protecting migrants, and I show it, and I don't need to show also that that category is underprotected in Tunisia because we already have the exception. So I agree, but your question is more challenging because if you add to that the reduction of due process guarantees, so isn't there the risk that we misses some relevant elements in favor of the applicant to the extent that we can return that applicant wrongly? And I would respond to that. Let's distinguish between the two dimensions. Imagine that, let me be explicit. Imagine that I am a gay person, okay? And that there is an exception or not related to gay person, it's not relevant. But imagine that I am a gay person. It's not easy if I convince the judge that I might be a gay person. Maybe that is sufficient. It should be sufficient for the judge to establish that the appropriate channel is not the special border procedure, but the ordinary one, in order for me to be allowed to prove with all the due requirements that I am a gay person. So that is sufficient. But imagine that I do not have any meaningful claim. Should the judge be entitled to review also in that case the legality of the designation of the country as safe? No, because if I do not have any claim, that is precisely where the border procedure should apply. And this is not about reducing rights protection. This is about preventing judges from rewriting a policy. Thank you.
Awesome. I don't know, I mean, I would say that we can close. I mean, if you agree, there might be further questions, and we will be happy to continue over the dinner. But it was really, really an enriching panel, a plenary session, actually. So I congratulate all the speakers, and I also say goodbye to you. See you in a couple of hours. Enjoy the rest of the day. Thank you.